Why not an appeal for converting it to 302?
Because there is,
Huh?
I have filed an application
Yes.
regarding that.
But the victim has filed.
We have,
Then
that's also pending.
we consider that, Mr. David.
With respect, but today there is no appeal.
There is an appeal.
There is no appeal. Please see the cause title. There is no appeal, my lord. For there is. Please,
No.
my
We
learned
are
friend
not concerned with cause titles, Mr. David. It's the victim here before us who
If
saying has filed an
my lord,
appeal.
if there is an appeal, it would have been taken up with the same matter many.
But we don't wish to comment.
But
Give the
where is
number
the
of the appeal to Mr. David so that he is better advised.
I'm not, my lord, today,
Please, you get the number of the appeal under appearance.
Mr.
which
David,
appeal, my lord, with great respect, there is no
Out
appeal
of-
on this matter.
out of 10 years or so, whatever sentence that has been awarded by the trial court,
Yes, my lord.
you have undergone actual sentence of 7 years and
Yes.
9 months or so,
Yes.
right? Less than
This
8
is
years.
Yes.
It's of
It
300.
is highly debatable whether an offence involving moral turpitude of such a nature,
Yes, my lord.
will you be entitled to claim any remission?
Yes, my lord, of course.
Anyway,
They can claim
we
commission.
are not saying anything,
Remission
we are
is a-
saying highly debatable.
My lord, remission is available even in murder cases, but after 14 years, you have to undergo 14
Murder
actual
case
14.
can be, you see, murder case can be sometimes a simpliciter murder.
But this is a murder
The
case
two
only.
groups are fighting out of certain on momentary issues, sometimes without any intention, sometimes it takes place, or it can happen. There are several
The
circumstances.
remission policy of Delhi government is clear. This is a term sentence of 10
Anyway,
years.
that issue becomes academic in the sense, once the learned solicitor is pointing out that your appeal is coming for hearing
On 11th.
on.
Yeah.
11th.
Yeah.
It was listed
So
on
we'll
third.
request the High Court to take up your appeal on day-to-day basis. They are not opposing it. They will argue from their side. Prosecution will also extend full cooperation.
Victim's appeal.
No, this is, I'm with great respect.
And
I have yet to come across a case where a person has undergone out of 10 with remission, with remission also 7 years, without remission also 7 years.
Yes.
And that
The-
no
yes.
suspension is granted to him.
Mr. Dave, the total period undergone by a convict is undoubtedly a factor that is kept in view while suspending the sentence. But why we suspend the sentence? Only when we are uncertain about the time that will be taken in the final decision of an appeal. Here is a case where the main appeal has been listed for final hearing. What is only is required to doubt to remove any kind of cloud on that certainty, we will request the High Court.
It was listed on third. As per the impugned order, it was listed on third, not taken up on third.
Why?
Because
Why
your
must
lordship-
not have been taken up? Because somebody must have pointed out that your SLP is
pointed
coming
it out.
before this
Nobody
court.
pointed it
There is
out.
a difference. There is a
No, my lord,
difference.
this is with respect, my lord.
Mr. Dave,
This
Mr.
goes to Article
Mr. Dave,
21.
right from all high courts in this country, including the Supreme Court, we have two categorization of two sets of criminal appeals before us, where the accused is on bail. We do not grant out of turn hearing in those matters because we know that there is no crisis of liberty. Bail have been granted. But in these cases where we do not deem it appropriate to release an accused on bail, that's a separate set of category where the appeals are taken out of turn. If your is a case, 2020 appeal might not be ordinarily, it will not come as per turn in Delhi High Court. But because you are there, you have not been granted bail, that's why the High Court is according you out of turn hearing. And we will cement that, we will further request the High Court, making it sure that your appeal is heard.
Appeal, it may be heard.
Not another.
Well,
thing.
just 1 minute, my learned friend.
Lady
Please,
is
just.
undergoing a life imprisonment in the second offense.
So what difference does
So
it
whether,
make?
my lord,
So I should not
it's
get
here
bail.
or not, my lord, doesn't make any difference.
Every time the argument is even better. Now, please see if for a 10-year term sentence, suppose it was not 304 part 2, suppose it was 307, attempt to life 10 years I've got. Would it still be that I'm not entitled to remission?
We are not required to look into these aspects. We are not saying, you see, as an accused, you see, this is one country who is so proud of on rule of law that even the most heinous, dreaded criminals, we have been according opportunity of hearing. This country has followed the rule of law. This country has provided a fair trial, even to the dreadest anti-nationalist elements, even terrorists.
Assad was
So even a person, as solicitor is pointing out, a person who came attacked so brutally on the integrity of this sovereignty of this country. We even provided fair trial to him
The
also.
offense was seen by the world on
No,
television.
what is my learned friend? I am not
Everybody
listing the
is
Kasab
entitled
matter.
to-
I don't know why my learned friend is on Kasab.
In
This is
your
not a
case
Kasab
also,
matter.
no, he is only illustratively telling that in the
This
worst
is trying to
cases
link
also.
me to Kasab. What do I have to do? I was a
You have
sitting
to do
MLA.
nothing, you have to seek an assurance from the court of law that irrespective of the nature of allegations, irrespective of anything coming in media, you are entitled to a dispassionate hearing of your criminal appeal by the High Court, which will be decided without being influenced by here and there anything, which should strictly confine to the evidence on record, material on record. That's all.
So now,
No, just-
may I just answer one question which fell from my Lord Justice Bagchi? My learned friend says he has filed an appeal. That appeal is for necessarily enhancement of sentence. It can't be for anything else. It has to be enhancement of sentence or change, or that it goes under 302.
Why not? Why not? It's
It goes to
302 charge was framed against you, one will
302.
be
I'm
300.
assuming against myself.
So there is a lesser offense on which you have been convicted,
Just
why
bear-
so to
no,
the?
just bear with me for the submission.
Yes, we can bear with you for a lifetime, Mr. Dave.
The enhanced sentence could also be death in that.
May I
case,
just
in my application.
indicate why I'm making this submission? If it is my learned friend's appeal, it goes to DB. This matter is before a single judge, it's below 10 life sentence,
Chief Justice
then
will
it
take
cannot,
care.
no, I'm saying if it is fixed on
In
11.
appropriate
just a
cases,
submission.
Mr. Dave, this sort of an appeal where there is a possibility of a appeal by the victim for enhancement, not a case for a division bench.
So there-
Yes, it's
there's no
for-
point, Manoj,
Simple
for
reason.
for 11,
Intract
for
court appeal.
11.
So
Mr.
nobody
Dave.
loses one appeal.
Nobody is arguing this. I don't know why the solicitor has not preferred any appeal in this
No,
matter.
this
The
is the
CBI is
case of-
sitting pretty.
This is not a case of any quorum non judice plea. These are all internal
Because when
arrangements
your
by the.
lordships are asking the High Court to expedite the appeal.
So therefore, in the case, suppose a division bench of the High Court, suppose prima facie feel that the appeal filed by the victim also should be heard along with your appeal. In that case, matter has to be listed before a two-judge bench.
So it can't be heard on the 11th in any case, since much submissions were made,
95
it's listed on 11th, hear it on 11th, have it on day to day, the other side is saying, though, it can't be heard, that's, I'm all pointing, the only thing I was pointing out.
Can be taken up on some.
So, Manoj, 10 years, assuming that he goes through his 10-year sentence, Manoj, his appeal would be infructuous, and if their appeal is dismissed, he's undergone the entire sentence.
Kind of
without
whatever
bail.
doubts you have in mind about listing, that we will clarify here. Both sides.
I'm saying, Manoj, if
Both
9
sides
years,
are
7
present
months,
before us, so
in 9 months, 7 months are not enough. If 9 months, 7 years are not enough.
As well as their.
We were not even charge sheeted in for murder by the CBI. It was a club trial, therefore.
We are not charging.
Look, may I just say,
The initial,
Shlodan heard this,
the initial charge
So
sheet.
I'm only saying, Manoj, 9 years, 7 months undergone, with remission, another 5 months I have to undergo. I will undergo that period. There is nothing else that is left, Manoj. Whether the appeal is heard or not becomes an academic question.
No.
Only if their appeal gets allowed.
There is
Only.
no criminal appeal becomes an academic issue. Even in those cases where unfortunately the persons died while pending the criminal appeal, because the family is still entitled to seek vindication of innocence. If there is an innocent person falsely or erroneously convicted by the trial court. So these are nothing to do, completion of sentence, anything, these are not the circumstances. which
Out of 10 years, 9 years, 7 months in custody, or 7 years actual custody, is more than 7 years.
We appreciate your contention,
But then
therefore
what
we
should
request
be
the
done?
High Court,
This is
to decide your appeal.
If I had come in any ordinary case, Manoj, I would have got bail. With respect, I'm just saying so, Manoj. When it came, the other matter came before your.
Jail for,
Just 1
life
minute, my the solicitor is not, there is no notice is issued in this matter. Now, because that other matter, when it came, we said that this is, it fell from the Honorable Chief Justice that you are not released in that matter. Therefore, we are staying that matter, in the bail in that matter. When we come in this matter, the solicitor says, in that matter, you are in custody. So how does it matter? Somewhere I have to start getting bail, or I'm going to be just in arguing my appeal or pursuing my appeal. And now the complaint.
We have already explained that in a case of conviction
On merits also.
and pending criminal appeal, what are the parameters normally we follow on uniform basis in all high courts and including the Supreme Court.
Yes.
Where the accused is inside and has not been released on bail,
My lord.
he or she is entitled to an out of turn hearing of the criminal appeal.
Yes, my
so that at least before completion of the sentence, the matter is heard.
My lord.
That is the principle followed. In your case also, there cannot be any exception. You are entitled to Whatever you are entitled to law, you must get it.
Yes.
Therefore, you are entitled to an out of turn hearing that the High Court is according. We will also make sure that you get it.
But that process is not available, my lords, because now the complainant feels that I should be convicted under 302. So his appeal first has to be.
Mr. Dave,
265.
for deciding
Now,
your,
EC 365.
for deciding your appeal, we cannot gag the right of a victim. If at all there is a right in law.
Mine also, my lord.
Yes, therefore balancing has to be done.
For 9 years, 7 months,
We are absolutely right to do, but there has to be a balance of rights.
I've undergone more than half of this actual sentence. Actually, I've undergone more than half, my lords. Kindly consider this. In which case, for term sentence, this is not a life imprisonment. Life imprisonment, I can understand the High Court has some leeway. Your lordship may have some leeway that it's a life sentence. There is no term there. But in a term sentence, my lords, your lordship always takes into account the period.
It is a term sentence of a person who has been convicted and sentenced to life imprisonment in another case.
Yes, my lord.
Isn't that a relevant consideration
Of
for
course it is, but in
suspension
that,
of
when
sentence?
that matter came up, my lords, the same argument was there that please stay.
Certainly, one will color the other.
So, my lord, even-
If there are,
That's what I'm saying.
why do we speak of criminal antecedent? When it comes to a question of multiple cases against an individual, courts are generally circumspect in granting
same incident.
pre-conviction bail.
Same incident. It is not a separate.
No, it's
incident.
definitely not the same
It's the
incident.
same- exact-
It's the
it's the same
motive,
incident,
it's
my
the
lord.
motive.
Allow me to.
The rape case is the motive for this crime.
In this case, here the person died in police custody. Person died in police custody. I was
Two
not.
police officers have been convicted.
Yes, my lord. And I have been with 120B. I was in Delhi. Those are the findings. I can show.
Let us not
Mr. Dave.
comment on the merits.
Mr. Dave, any argument touching the merits from your side will invite a reaction from our side unnecessarily. And you know this matter that unfortunately it's not that we are not sitting in ivory tower. We know that there is a media trial also going on, which we do not really approve. And the way Mr. Prachap outside the court, he goes to the media. If you are a counsel, you have no business to go there. Don't forget, I have saved you in profession. Your license would have been suspended, your exemplary costs were imposed on you by the High Court. I saved you thinking that you will believe in professional ethics. You have no business to go to media when you are appearing in a case here. If you find that you are indulging in this kind of drama, then you will face the consequences also.
Can I just say?
As a Chief Justice of India, I can't tolerate these things.
Let's kindly see what the other side.
You are arguing here, you are conducting a parallel trial outside the court. This is not acceptable.
I was just informed.
We are only warning you today. You take this warning in the right earnest. That's all.
Can I also tell this that please tell this to the other side also.
Right now.
What
They have-
side? I never went and gave interview in the
Now
other side.
we have conveyed our message, and anybody knowing that how I function, I hope that people will believe it and follow it.
May I just say?
Then may I only suggest.
Do not invite any
Let the
consequences. That's
DB
all.
take a call whether his appeal is maintainable or let the
The
DB.
other side also.
You have a right to oppose. He has a right to
No,
argue.
I'm saying let the.
You will argue in court. That's all.
Because the division bench, since your lordships are asking for expeditious, let the DB first decide whether his appeal is any merit in it or not. Then call
The
for
way,
my appeal.
the way that you will argue before division bench of the High
Leave
Court,
that.
not before us.
Expedite, then I'm only praying, don't expedite this simpliciter, my lords, my matter. Because it will be tied up with the division bench matter.
Right now. The petitioner, say leave granted. The appellant is agreed by an order dated 19th January 2026, passed by the High Court of Delhi, declining his prayer for suspension of sentence and consequently release on bail in criminal CRLA number 539/2020. The declining his application under section 389 in bracket 3 CRPC, seeking suspension of sentence and so on. The above stated criminal appeal has been directed against a judgment dated 4th March 2020 of the trial court, by which the appellant was convicted for offences under sections 166, 167, 193, 201, 203, stroke 21, stroke 21, 212, stroke 323, 341, 304, 120 capital B IPC, and sections 3 stroke 25 of the Arms Act. We just make sure that correction in this section. He was consequently sentenced to undergo a rigorous imprisonment of 10 years.
Yes, my
10
lord.
years.
Highest is 10 years amongst all of them. The highest sentence amongst all of them is 10 years.
Terms, maximum of which
He
was
was a maximum tenure of maximum RI for 10 years, though different sentences were awarded for different offences. Those separate sentences were awarded for different sentences, offences.
And all directed to run concurrently, my lord.
Next paragraph. It seems that the appellant, besides arguing, besides making an attempt, a case for suspension of sentence and release of bail on merits, also vehemently urged before the High Court that he has already undergone an actual sentence of 7 years and 9 months out of the total sentence.
With
And-
remissions, with remissions.
Huh?
7 years, 6 months, 29 days with actual. My learned friend is not aware since I'm in custody, and 9 years, 7 months with remission. So 7 years and 7 years and 7 months of actual custody.
7 years or 7 months of actual sentence. Anyway, that's a matter of calculation.
No, it's there, my lord, at
Next paragraph.
46.
The High Court has wide impugned order one more line. The appellant also urged that some of his co-accused had already been released on bail after suspending their sentence. Wide orders dated 22nd September 2023 and 17th October 2023. The High Court, however, wide impugned order has declined the suspension sentence and consequential release on bail, interiorly observing that the appellant is already serving a life sentence for the rape of the deceased minor daughter in a connected case, semicolon, that his previous application for suspension sentence was dismissed on 7th June 2024, and there are no new exceptional or compelling circumstances, etc., etc. Next paragraph. The agreed appellant is before us. Next paragraph. At the outset, it is pointed out by Sri Tushar Mehta, Learned Solicitor General of India, representing the Central Bureau of Investigation, that criminal appeal, criminal LA number 539/2020 of the, that the appellant's criminal LA number so and so is now listed for hearing before the High Court on, what is the date, Arvind?
11th.
On 11th February
Along with the-
2026. He thus submits that the High Court can be requested to take up that appeal, to take up and decide that appeal on out-of-turn basis. Can may be requested to take up and decide that appeal on merits, on out-of-turn basis. Next paragraph. At this juncture, counsel for the
Complainant.
victim states that the complainant side has also filed an appeal challenging the trial court judgment dated 4th March 2020 on various grounds, including on the question of quantum of sentence. Next paragraph.
Which is pending before the division bench.
Since there is no reference to that appeal in the impugned order of the High Court, comma, we do not express any opinion in relation thereto. Next paragraph. Keeping all the attending circumstances of the case, comma, especially the period of sentence already undergone by the appellant, comma, we deem it a fit case for requesting the High Court to accord out of turn hearing in criminal LA number 539 of 2020 and decide the same as early as possible, comma, but not later than 3 months. But not later than 3 months. Next paragraph. As regard to the criminal appeal, comma, if any, comma, filed by the complainant party stroke victim, comma, we grant liberty to the appellant in that case to approach the High Court for taking up of that appeal to for hearing. Full stop. The High Court is requested to firstly take up that matter within 1 week and subject to the objections maintainability, etc., comma, if the High Court find that the said appeal to
All issues can be decided together.
Huh?
Then
maintainability, etc., comma, it will be in the interest of justice that both the appeals are heard and decided together. Heard and decided together. Full stop. If such a recourse requires the change in composition of bench for deciding criminal LA number 539 of stroke 2020, comma, Honorable Chief Justice of the High Court will do the needful in this regard. Anything else you want?
There are 8 connected appeals which have to be decided with this 539 of 2020. They are all co-accused. So it's not my appeal. There are 8 connected appeals.
Connected appeal of other countries.
With 539 of 2020, the present appeal. So they all have to be decided together.
If there are, next paragraph, if there are other connected appeals, those two also be taken up and decided along with the lead appeal, along with the lead case.
Then if it is not decided in 3 months, my lords, then where do I go?
Yeah,
So then I'll be back before.
Incidentally, I am not retiring in 3 months. My brother or both in any case will retire after me. So there nothing is that unforeseen circumstance we should see.
I have